Good morning and welcome to today's webinar, What Families Need to Know About Planning for a Loved One with Special Needs, presented by Elville & Associates Managing Principal and Lead Attorney Stephen Elville. My name is Jeff Stauffer, Community Relations Director with Elville & Associates, and I'll be moderating today's presentation. So how this will work today, if you're new to our webinars, if you are, welcome. We're glad you're here. And if you're coming back to see us again, thank you for being here as well. We appreciate your support. So you as the attendee are in listen-only mode. However, if and when you have questions, please note them in the questions panel on the right-hand portion of your screen, and we will take time throughout the presentation to address them. Your questions, as I always say, really help the presentation and they add value. They help others learn. So please don't be shy in posing your questions at any time. You received the presentation yesterday by email from me to take notes on it if you wish. If for some reason you did not get the presentation yesterday, it is available in the section marked handouts in the panel on your screen to download at this time. For CFPs, CPAs, and other professionals on today's webinar, welcome. You also may receive 1.5 continuing education hours for attending today. For my attendance records requirements, please email me your board ID number. And for CFPs only, I also must have the last 4 digits of your social security number as soon as possible so I can submit your CERs for approval, which I'd like to do by Monday. Everyone will also receive a post-webinar feedback email right after the presentation. And we do ask that you please just take a couple minutes to fill out the simple survey to offer us your feedback about today's presentation. We value every comment and we read every single comment. It's also an ideal time to request a consultation with Steve for any planning needs that your family may have now or in the future. And we always look forward to being a resource to you here at Elville & Associates. So briefly, I'd like to offer you an overview about our firm and share a little bit about Steve before we get started. For those of you that are new to our webinar series in Elville & Associates, so you should be able to see my screen here. Elville & Associates, we were founded in 2010 by Managing Principal and Lead Attorney Stephen Elville. We have a number of different practice areas that we focus on here at Elville & Associates, including estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and a busy litigation department that works in tandem with our other practice areas, and tax planning and asset protection. We have 7 attorneys, 12 staff members, and 5 locations, and Steve and I are coming to you live from the Columbia Gateway community location today. Our mission, as it always has been and always will be, to provide practical solutions to our clients' needs through counseling, education, and superior legal technical knowledge. We do offer a lot of education here at the firm, as you're going to hear throughout today's presentation, and we do that in many ways. Through our planning processes with our clients, we offer over 100 educational workshops and webinars in the communities that we serve each year, and also by way of our accredited client care program, or CCP as we like to call it here. We are one of only 2 firms in Maryland to have an accredited CCP through the Client Care Academy in Boston. We also work with the ideals of client education, collaboration, and compassion in mind with every client, every time, every day. A little bit about Steve. His work as an attorney for the past 20 plus years, 22 to be exact, has been centered in elder law, special needs planning, and estate planning, with an emphasis in the areas of tax planning and asset protection. A member of many different national membership organizations, including the National Academy of Special Needs Planners. He works to bring peace of mind to clients by creating solutions to their needs through counseling, client education, and the use of leading-edge legal technical knowledge. A very seasoned speaker, if you haven't heard Steve present before, talking at many webinars, workshops for businesses and their employees, conferences, and continuing education events each year. Also named to the Maryland Super Lawyers list for a 7th time in 2022 and a 6th consecutive year, so congratulations to Steve. And he also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charitable organization he founded in 2014, and I'm privileged to be the executive director of. So if you'd like to learn more about the Elville Center and how we work to make a musical difference in the lives of children each day, please reach out to me and I'll be happy to share our story. I could talk for hours about it, but we don't have time to do that right now. So reach out to me and I'll be happy to talk to you and let you know a lot about our activities and what we do at the Elville Center. So with that being said, we're going to go ahead and get started. We have a brief poll to get to know our audience and see what's brought you to our webinar today about special needs planning. I'm going to go ahead and launch that right now. And the poll is pretty simple, and it is to get to know our audience. Please tell us what has brought you to today's webinar. And it is launching slowly. And your choices are: 1, I need to set up planning for a loved one with special needs. 2, I have planning in place, but it needs to be revisited, which is not unusual. 3, I'm a financial advisor here to learn to benefit my clients, which is always great. And 4, I'm an interested family member here to gather information. So please just take a minute to make the choice that best suits your situation so we know who we have here today with us. Once again, welcome everybody. Okay, with about 85% of the votes having come in, 48% say I need to set up planning for a loved one with special needs. 8% say I have planning in place, but it needs to be revisited. 12% say I'm a financial advisor here to learn to benefit my clients. And finally, another 32% say I'm an interested family member here to gather information. So thank you for being here today, Steve. I'm going to go ahead and turn it over to you and click that button to make you the presenter. I think you know the drill.
Thank you, Jeff. I see the button and I'm now taking control of the screen here, and let's see if I can get to the presentation. And I'm going to start my slideshow.
Great.
Thank you so much. And good morning, everyone. And thank you for being here on a Friday morning and spending your valuable time with us. I'm here in conference room number 1 at Elville & Associates here in Columbia, Maryland. I'm looking out the window here and I see a beautiful day outside, so I hope it's beautiful where you are. And I hope you're safe and well this morning and enjoying the beginning of spring. I want to thank my good friend and colleague Jeff for his great work in helping me put on this webinar today, as he has so many times. And Jeff is an expert moderator. He will take your questions. He will do everything he just described and do it very well. So we'll be sensitive to your needs this morning. And I am very blessed to be here with you, to be a part of the special needs planning community, and to be in a position not only as the principal of Elville & Associates, but to be able to educate. And we want to do that today by giving you the information you're looking for to be able to make informed decisions about special needs planning. And as part of that, I'm going to be communicating a lot of information to you this morning. Some of it may be overwhelming if you haven't heard this before, but my goal and our goal is to impart some substantive knowledge to you today, and that you can use this handout, this presentation, as a tool. You can actually refer to it. It's got a lot of wonderful things that really help you understand the highest and best way to approach special needs planning, even if you don't understand all of it today. So that's my job, is to help facilitate this education and to lead you through what I will call maybe a mini master class on special needs planning. Certainly this doesn't cover all aspects, but most of the aspects, at least from a high level. And we also want to facilitate a path forward for you to actually do something, to be able to explore the planning that you need, or if you have the existing planning that I heard some of you may have on this webinar, to know that we're here to help you to review that and to update that planning. And so we're here to help, we're here to educate, but we're also here to facilitate. And we're going to give you some paths forward this morning to not only take this knowledge and understand it and think about it, but also to move forward, get some planning in place. Okay, so through this medium of time and space, through these webinars or wherever you are, I'm going to start now, and please relax. Know that this is an informal presentation. Enjoy, get your pencil or pen out or make notes on your computer, and we're going to go ahead and get started. Thank you again for being here. So there are many reasons to plan, and no matter what kind of planning we are talking about, whether it's tax planning, charitable planning, estate planning, elder care planning, or special needs planning, all planning is goal driven. G-O-A-L, goal driven. And I want you to remember that there are certain goals you will probably have or do have in your planning. And if you are not quite sure what your goals are, I would have you start to think about that, because one of the things we believe in here at Elville and Associates is giving you the time to think. My experience is that many special needs families with a loved one with disabilities, do not have time to think. They don't have a lot of time to think about some of the concepts we're going to talk about this morning. That's essential to think about what are your goals and how can I get from point A to point B to accomplish my goals. But one of the main goals, as we see here in this slide, is that special needs planning is about enhancing the person with disability, their quality of life, enhancing and maximizing their potential, but without restricting their potential. So I want you to start thinking about these broad concepts as they relate to you. Now, there's lots of benefits of planning in general, but of course, in special needs planning, well, what are we trying to do in a general sense? We're providing financial security. We need to understand public benefits and leverage those in most cases, not all cases, but in many cases. We want to have a lifetime team. We want to have a management team. And we're going to talk about this a few times this morning. We want to talk about housing. How are you going to address housing for your loved one? And I know many of you, this is very, very near and dear to your hearts, the housing issue. Who is going to advocate for my loved one? Who is going to continue to look at their caregiving needs over a long period of time? Who's going to coordinate that? And how is my loved one protected from creditors or fraud? And for some of you, preserving assets for other family members is an issue. So we're going to continue to talk about all of these things. Take this as a start, as a foundation for your thinking. So some of the things we're going to be talking about today, I'm going to repeat. I'm going to repeat several times, and that's intentional. And Jeff and I laugh about this. We call this intentional redundancy. We're going to talk about things more than once to try to drive home our points. So again, we want to have a team. We want to have a team of advisors. What do I mean by that? Well, an advisory team would include your lawyer, your planning attorney, you're a special needs planning attorney. It would include ideally a CPA, a certified professional that's an accountant, a certified public accountant. It would also involve a financial advisor, and it most likely would involve an advocate, a life care manager. We're going to talk about that. It also could involve an insurance professional. Your financial advisor may or may not be an insurance professional or someone who wants to delve into the issues of life insurance, which can be so important in special needs planning. So we want to think about an advisory team. We want to have advocates. We want to have someone in place, and many of you do have these people in place, these organizations in place, that can provide advocacy for your loved one. We also want to provide for flexibility. So as we look at the middle bullet point there, it says making sure the plan is flexible. How much is going on in the world today? Look at all of the concerns that we have with COVID-19 and the situation overseas with the war and all of the concerns that we have, not only in our own worlds with our loved ones, but outside of our nuclear world. And the issue there is, are we planning for flexibility? Trust protectors, which some of you may or may never have heard of, a trust protector is a flexibility tool that you can build into your special needs planning. So we want to have a team, we want to have advocates, and we want to build in flexibility in most situations. So let's talk about how we start to think about all of this. Well, again, we want to take the time to think. Here I'm sitting in conference room 1 at Elville and Associates, which was our biggest conference room. We have 3 conference rooms here. This conference room is dedicated to lots of space, lots of places to spread out, and lots of time to think. We want to give our clients the time to think. And what are we thinking about? Well, where will our loved one live in the future? What type of care is required? Will a guardian or conservator be necessary? Who are the players that I will have in the future for my loved one, or that I'm going to put into place now to care for them and to gradually go into the future with? What are the potential challenges that we may be facing? And as I think about that, as you think about that, what layers can we build to deal with those future challenges? And then back to the basics. Are we really following our process and our purpose? We want to have a process to think through these things, and we want to have a purpose or a goal in mind. Now, one of those things that we should be putting in place is something that's more concrete, and this is a memorandum of intent. Now, if I had 1,000 wills or 1,000 trusts or 1,000 special needs trusts sitting here, what would be the thing that differentiates them one from another? What will differentiate your special needs trust, let's say, or your planning? What will differentiate that between you and the next person? Well, I'm going to give you a simple answer on that. There's not going to be much that's going to differentiate that. Yes, some of these documents are drafted differently, and some of them are drafted more correctly than others, and so forth. The issue I'm talking about here is personalizing your documents, and you can do that through a memorandum of intent. We call that a special needs planning memorandum of intent. And this is a guide. We can give you a template for this. We can give you a way to start thinking through this issue, or you can develop one for yourself. And through this memorandum, you can lay out everything that's very personal and very medically related and very intentional on your part about what you want for your loved one. What are the key things that are going on in their lives? What are their eccentricities? What are their wishes and desires? Their functionality, their medications? You can lay all this out. Now, why would you do that? Well, trusts, for example, a special needs trust can last forever in Maryland. So special needs trusts can be around for a long time, and forever is a long time. And even if we don't think in terms of forever, we know that throughout the next several years or the years following your passing are going to be critical years for your loved one. So this will guide not only your current trustees, the people that you know will serve for you, but it's also going to be for those unknown people who may serve in the future. So this memorandum of intent is something we're happy to share with you to start your thinking along the lines of this process. And Jeff is going to be happy to send that to you. This is possibly the most important thing, other than the basic structure of the planning. This is probably the most important thing in special needs planning. Now, we also want to be thinking about expenses and resources and how will we fund the future? How will we provide for those basic necessities in the future? Not just the public means tested programs that we have all become familiar with and depend on, which hopefully will always be there, but how are we going to meet other expectations and goals financially? And this is where I'm going to encourage you to use a financial advisor. And again, my experience with many special needs families is they struggle in this area. They don't necessarily have a financial advisor or a financial advisor they feel understands their situation. So we want to use those financial advisors. If you are on this webinar this morning and you do not have a financial advisor, we are happy to help you find one and also develop a team. I'm going to give you just a few very old-fashioned examples of what I would start thinking about if I were you, about the current situation, about the future situation. These are old-fashioned spreadsheets to start thinking in terms of cost and projections. And remember, your financial advisor, depending on who they are and where they are affiliated, they're going to have tremendous resources to be able to run projections and give you all kinds of tools for success. And we can collaborate together to put together more than one mind and several sets of eyes on the planning. So just know that if you're not utilizing the resources that are available to you, they are available, they are out there. We also want to consider our loved ones' capacity or incapacity. So if they have the capacity, they are a higher functioning person with disabilities, and they have the mental capacity, they should, in most cases, sign a financial power of attorney and an advance medical directive. What does this do? Well, this will help you as their loved one. Most likely you would be the person who would be appointed as the agent. And you'll notice I said agent, not guardian, because this avoids guardianship. We want to avoid guardianship if we can. Well, this higher functioning person can appoint you, and you can provide for their management, for their health care, and for their financial affairs without the need for a guardian. On the healthcare side, what is so important about this? Well, it's the HIPAA waiver. It's a waiver that gives you the right to access their medical records. So this is very, very important. HIPAA is very strong. And once your child or loved one is over 18, now the HIPAA laws are protecting their medical records as an adult. So we want to get past that if we can. Now, let's say our loved one does not have the mental capacity, which is in many cases the situation. They clearly don't have the mental capacity to sign powers of attorney, or it's not appropriate for them to sign. Now we're talking about guardianship, guardianship of the person, guardianship of their property. So we want to address this honestly. Many parents have such high hopes for their children, and they don't want their children to have to lose their rights in guardianship or conservatorship. So this is something that's a counseling issue. We also want to hopefully see the supported decision-making law in Maryland, which is a bill, I should say, not the law yet, the supported decision-making bill, which would allow a person with disabilities to make decisions for themselves, provided that they have the support to do so to whatever extent they can possibly make their own decisions. So the District of Columbia has this, DC, Delaware has it, Wisconsin, Alaska, Texas, Indiana, and several other states. And hopefully Maryland will see a supported decision-making bill passed. So far, so good in this legislative session. It got favorable reviews in the Senate in Maryland, and hopefully so in the House. And hopefully this will be another tool that can not only help avoid guardianship altogether, but it can also be a tool where a judge could actually use this supported decision-making as part of guardianship. So the person who even might have to be under guardianship could still make their own decisions to whatever extent possible. So this is a wonderful thing, and we are happy to provide you with more information about it. I was very privileged to be able to provide testimony to the House and Senate in the Maryland legislature just this last several weeks, and hopefully through the joint efforts, and the majority of effort has been by Disability Rights Maryland lawyer Megan Rusiano in this regard. So hopefully Maryland will join the ranks of those states that has supported decision making, and in doing so enhance the rights of people with disabilities and fulfill the United Nations mandate on human rights. All right, that was a mouthful, and I appreciate your attention through those last several minutes. Jeff, I'm going to stop just to see if there are any questions so far.
Thanks, Steve. We do have one question, and the question is regarding supported decision-making. It is supported decision-making law. Can this be used for someone without mental capacity?
That's a great question, and I'm going to try to answer it fairly quickly, but it's a very broad answer, and if we had time. The concept of supported decision making is that a person that has very little mental capacity still has some capacity. Most people, not all, most people with disabilities may be able to evidence some kind of intentions and self-determination. So the concept is that even a person that is severely disabled could and possibly could evidence some kind of desire. I want to go to the ball game. I would like to buy a hot dog, or be able to indicate some personal preferences. So this concept is that a person with disabilities should be able to direct their own lives to whatever extent is possible. And society, meaning our state of Maryland, if they are willing to provide the necessary support, then they would enable this person to be able to do that. So if someone has absolutely no mental capacity, then I would say no. But if they have at least some ability to direct their own self-determination, then despite the fact that they might be deemed in the general sense, in the traditional sense, to be disabled, they are still deemed under the supported decision-making idea to be able to direct their own lives to some degree. And so that's the best answer as I can provide right now. That's a wonderful question. Thank you.
And also related to supported decision making, what is the bill number and title of the supported decision making bill?
Thank you. I'm going to, please don't hold me to this. I believe it is SB 559 and HB 556. Now I will have to tell Jeff that he'll need to make that more clear after today. I don't have
I can,
but I believe that's what the bill is.
I can certainly look that up and provide that in my follow-up email to everybody. Thank you for that question. And the other question, and then we can move on. The attorney who set up my son's special needs trust in 2005 is deceased. How can I update this trust?
Thank you. So this sometimes happens with deceased lawyers and relationships that have been in the past. So in that case, what would happen is if that person's office is still in existence, you could have your file transferred to another attorney, including all original documents. Or if that law office is no longer in existence, or their file is no longer, your file is no longer in existence at that office, which I hope is not the case, you can still just bring your current documents and then you can bring that to a new law firm and you can be represented.
Okay, Steve, thank you. Those are all the questions for now.
Thank you for those wonderful questions. Really good. Let's look at public benefits at a glance. Many of you are familiar with SSI, Supplemental Security Income, and Social Security Disability. I'm just going to lay this out. I'm going to talk to you as if you don't know anything about this, but I know that many of you do. Let's get into this chart and let's try to make sense of it. And what are we really trying to say today? We're really trying to say that not only should you understand this, but your future trustees need to understand these benefits. I'm going to stop right now and give you the name of a book that I recommend you read, or a book that I recommend you buy and give to your potential future trustees. And don't be put off by the title. It's called How to Administer the California Special Needs Trust. How to Administer the California Special Needs Trust. Now, there are many books, but this one is very easy to read. It's written by Kevin Urbash. Urbash. He is the past president of the National Academy of Special Needs Planners, or I should say the Academy of Special Needs Planners. He's a very successful special needs lawyer in California. This is a wonderful book that is very clear about benefits. Supplemental security income is for someone who's over 18 and disabled. It is the quintessential definition of disability, but it also could be awarded to a person who is not yet 18 if they live in an impoverished household. I'm going to assume that most of the people on this call are going to be interested in SSI for their adult child once they turn 18. So as a result of receiving SSI, which is means tested, it is a means tested benefit. As you know, probably on this call, your child or this person with disabilities cannot have more than $2,000 of assets in their name. If they have $1 more, they will lose their means tested SSI benefit. As a consequence of receiving SSI, the disabled person, will automatically receive Medicaid, or in Maryland, we call that medical assistance. So I want you to think of this left column as the quintessential disability test. Now, when this person is either having their own work record, which in many cases is not the case, but it is in some cases, or when their parent retires or dies. If this person with disabilities was disabled prior to age 22, we're going to see another slide on this, they will transition. And I find that many parents and loved ones with persons with disabilities don't understand this. So let's think about the left-hand column. The person who was receiving SSI will transition to the middle column. This person will now, if they were disabled prior to age 22, they will receive SSDI, Social Security Disability, either under their own work record, but that would not be the case in the example I'm just giving you, but they would receive it under their retired parent's work record. So this person will receive 50% of the amount their parent receives. If the parent retires, they will also receive 75% of that amount when the parent passes away. So this person who transitions from SSI to SSDI is called a disabled adult child if they were disabled prior to age 22. That person will now receive Medicare. They will receive Medicare. Many of you on this call know what I'm talking about, but they also will receive Medicaid. So many people in this middle category, if we want to call these categories, will receive Social Security Disability, Medicare, and Medicaid. So there are means tested benefits in the left column. If we have more than $2,000, we're going to lose those benefits. There are also means tested benefits in the middle column for the person who is receiving Medicaid in addition to Medicare. Is Social Security Disability means tested? The answer is no, it is not means tested. So these are very confusing concepts, but just what I'm trying to drive home here is that the person on SSI, if they were disabled prior to age 22, they will become considered a disabled adult child. They will get a benefit that has nothing to do with their own work record in those kinds of cases, and they will receive Medicare and Medicaid. The other column on the right, we're not going to spend a lot of time on, except to say that the person who lives in HUD housing, or Section 8 government housing, that beneficiary is a very difficult beneficiary to provide for, because HUD will consider basically any distribution to the beneficiary or for the benefit of the beneficiary to be a benefit that is going to cause them to increase the rent. So if this person is paying rent, which they would be, their rent would be increased. So we have to watch that situation if your loved one is ever living in HUD housing. Now, in the interest of time this morning, I'm not going to spend a lot of time on the test for SSI. I will just tell you that when the time comes for your child or your loved one to apply for SSI, it is best that they be represented by an attorney, but it's not absolutely necessary, but it is something that we recommend. This is the definition of disability. We're not going to spend a lot of time on that this morning because we have so much to cover. But here's the SSI Resource Test, whether it's a single individual or a couple. And this is something that we want to watch out for. We don't want our loved one to lose their SSI. But notice, and this is something that is not something that is well known, remember that the person with SSI can own their own home. They can own a home and still be on SSI. They can own a car or a vehicle and still be on SSI. That doesn't mean it's a good idea. It just means that they will not lose their SSI if they own a home or a vehicle. Now, most of the time, a person with disabilities, we generally would not want them to own a home in their own name. We would have them own a home inside of a trust. And the Special Needs Trust, which we're going to look at here in just a few minutes, does provide for this ability to own a residence, if that's appropriate, to own a residence inside of the trust. The trust can also own a vehicle, such as a van, a specially equipped vehicle. So just know that this is not uncommon, and you do not need to be concerned about whether the person who receives SSI will be eliminated from SSI just because they have these assets. Now, SSI is for food and shelter, and if we are providing for food and shelter for our loved one, we know that our loved one will lose one third of their monthly SSI benefit. So this is something that's important to remember, and it's something that's fairly easy to avoid. We don't want to lose that one third because this is not that much money to begin with. So please do not lose that one third by providing food and shelter, meaning when you do provide food and shelter, meaning your child is living at home or your loved one is living with you, and Social Security reduces the SSI amount by one third, there are ways to work around that. So just let us know and we will talk to you about that. Remember that your loved one on SSI, supplemental security income, they can lose their SSI if they have too much income, earned or unearned income, and we don't want that. We don't want them to have their SSI reduced to zero because that means they would lose it. They would lose their Medicaid. So we don't want that. And there are ways of thinking about that. So just know this is an issue. Many of you are torn. Many of you are not happy about this because, and rightly so, because you want your child to be productive. You want them to be happy. You want them to have a job. And many of them do and are happy having productivity in their lives. But we don't want them to make too much money, and we have to be cognizant of that. This is what I'm talking about the one-third reduction. There are two concepts in SSI. I'll use the simple one, which is the in-kind support and maintenance. If my disabled child is living with me and I'm paying for their food and shelter, obviously, they will lose one third of their SSI benefit. That's the most they can lose. But we don't want them to even lose that, and there are ways of working around that. So this is the SSDI now, Social Security Disability Test. I'm not going to spend a lot of time on this. You can use this as a tool. You can review this yourself. But I will spend just a second here on this slide, and this is illustrating what I just talked about earlier. The disabled adult child, the person who was disabled prior to age 22, and their ability to receive Social Security disability now and to transition away from SSI once their parent retires or dies. Medicaid and Medicare, these are references for you to review what that covers and some of the tests. We talked about Section 8 housing. This is housing, and just in general, is one of your greatest concerns, and we understand that. I actually have some clients whose children live in Section 8 housing. One client in particular has a child who lives in Section 8 housing in Rockville, Maryland, that is actually quite nice. But we do have to be aware that distributions from a special needs trust for the benefit of a beneficiary of a special needs trust will increase the rent. And this is an age-old problem. There are ways of working around that by using an ABLE account, achieving a better life experience. There are ways of dealing with that. Purchasing a home. You're going to be thinking about this during your lifetime. Some of you may have already purchased a home or a condo for your high-functioning child with disabilities or loved one. So you can leave your residence into a trust for your loved one. You can have the trustee of the trust purchase a residence for your loved one. You can say, we're not going to be going that route. We're going to be relying on group homes or group housing or means-tested housing through the Medicaid system, this is a counseling issue and something that I know is near and dear to you. All right, well, now we're going to start the discussion of special needs trusts. And I'm looking at my watch, and it looks like we are about halfway through the presentation, a little bit more than halfway. And I'm just going to keep going, Jeff, until you might interrupt me and say we have more questions.
Steve, we do have a couple of questions. If
Sure,
we could
that's
maybe
fine.
pause for just a minute or two. Let me get to the first one here. And the first one is, can the person be moved from guardianship? Let me see if I can read this properly. It's a little unusually worded. Can the person be moved from guardianship, person, or properly to other options, either to new bill or POA options? Does that
That's
make
a great
sense?
question. Yeah, if I understand the nature of that question, which I think I do, thank you. The answer is yes. A person who's under guardianship does not necessarily have to stay under guardianship forever, even though many people think and believe that guardianship, practically speaking, is forever. It's not. And a public guardianship has to be reviewed every year by the court. A private guardianship does not have to be reviewed every year, which is one of the problems. So if a person who was deemed to be in need of a guardian, if that person can show that they have two physician statements showing they are not incapacitated, then I would argue that we could meet and discuss petitioning a court to remove the guardianship or to terminate the guardianship. So that's the nature of your question. Thank you.
Okay, next question. If you document with SSI that you charge rent, will you need to claim that on your taxes and income?
Thank you for that question. So to my knowledge, yes, that would be considered taxable income to you. And I'm sorry that is the situation, but I believe that is correct.
Okay, and that's everything for now. Thank you.
Thank you. Thank you so much, Jeff, for those questions. Now let's talk about special needs trusts. There are two types. The first is the third party type. That's the one that you're going to be most concerned about. That is the one that is the basic bread and butter of estate planning that you would want to include, and many of you already have, a third party supplemental needs trust. Anyone can establish that except the beneficiary. Anyone can fund that trust. You can fund that trust at your death with your will or trust, or your retirement assets, or life insurance. You can fund that trust now during your lifetime. There are others who may wish to fund that trust. Let's say relatives or siblings or others who may be willing to, wonderful people who are willing to leave assets to that trust. So this is a great thing. It is considered to be the assets that are coming from others, not the assets of the disabled person, and therefore there is no payback to the state of Maryland. So this is where we want to be. This is what we want to perfect as part of basic estate planning. Now, you'll notice in the right-hand column, it says what happens to these assets upon the death of the disabled person, God forbid. Well, what happens is those assets go where you say they go. Those assets go without any payback to Maryland. They go where you say they go. Now, the next two horizontal categories, the D4A trust and the D4C trust, if you're taking notes, these are what is called first party trusts. These are not third party trusts. These are trusts that the loved one, the disabled person, has assets in their own name. They shouldn't have those assets in their own name. A good example of this, I'll give you two examples. One was one that comes to mind where I saw a 15-year-old who was on the autism waiver receive a large IRA from a well-meaning relative. So that is an example of someone who should not have that money in their name, and that has to be moved out of their name into a first party trust because that is their asset. They actually were going to receive it and are deemed to have received it. Notice that a first party trust can be established by a parent, grandparent, guardian, or court, but also it could be established by a competent, high-functioning person with disabilities. So that's a fairly new phenomenon, but there is a payback. So if this person with disabilities dies, God forbid, their funds would first be paid back to the state, wherever they may live, and then the remainder beneficiaries can receive funds. So this is a typical situation where we're going to see some examples of where this happens when someone comes into funds that they should not have. A pooled trust, a D4C trust, is a trust that is usually run by a nonprofit. There are 4 different pooled trusts, such as the Arc of Northern Virginia, that's in our general area. These are trusts that are first-party trusts, and they are for someone who is either over 65 years of age or someone who is looking for a very low-cost approach. So the third-party trust, the one that we just talked about, is the best kind of thing because it is established with the assets of another person, and it does not have to be scrutinized and is not scrutinized by the state, and it has no payback. Now, some families, and I know this won't be you, some families, they kind of engage in practices about providing assets for their loved one that they really shouldn't. These are not recommended. So let's look at this. Leaving an outright inheritance to someone with disabilities. Well, obviously you're not going to do that. That's why you're learning and educating yourself and you're on this webinar this morning. Some people inadvertently, usually through poor advice or oversight, leave money in a trust that is not a special needs trust. They actually leave assets in a support trust, a trust that might be for a person's health, education, maintenance, and support. That is a support trust and will disqualify your loved one from benefits. We don't want to do that. We want to leave assets to a discretionary trust, and that is the special needs trust, or what we call the supplemental needs trust. That is a discretionary trust, not a support trust. Disinheritance. Well, this is not going to work well, and let's see why. Well, I'm going to disinherit my child because I'm afraid of the planning process or don't know what to do. I'm going to leave it to their sibling, or I'm going to leave it to my brother. I'm going to leave it to my parent. Well, look at this. That asset is now subject to the creditors of that person, if they have any. What if they die? Well, they might not intend to do this, but they just suddenly died and they left the assets to someone else by law. So the assets are lost. What if that person decides not to take care of your loved one, but you've left them the money? What if they got divorced? What if Uncle Sam were to take a tax lien against them? So we don't want to go with these things because these are huge mistakes, and we want to avoid these approaches. So again, back to the third-party trust. This is a trust for the person by a third party like a parent or grandparent or other loved one creates this trust. It is funded with the assets of the third party as well, or other third parties. There's no payback. It actually can be revocable during your lifetime. So that is a nice thing to do to avoid tax reporting during your lifetime. But it certainly will be irrevocable at the time of your death, even if it's not irrevocable during your life. At the death of the person with disabilities, many years from now, the funds that remain in that trust can go to whoever and whomever you wish. Choosing trustees. Let's switch gears here for just a second. Jeff and I gave a workshop, or I gave a workshop yesterday, and this was the main topic. How do we choose? How do we think about choosing trustees? So you want to think in terms, in a nutshell, whether we're going to use family members, professionals, professional trustees, let's say, corporate trustees like a bank or other independent trustee, although an independent person would still qualify, individual would qualify as an independent trustee. Whether you want to use an attorney, whether you want to use a CPA. So we have to have some benchmark. So we want to think in terms of a trustee that understands public benefits. We talked about that early on. It's going to also depend on the amount under management. So if we have a modest amount in the trust, we probably don't want to use a professional, or we can't use a professional or a trust company. How much oversight do you want? What are the family relationships? And I know many of you do have these wonderful family relationships and you are depending on your loved ones to be the trustees. But I want you to think in terms of what do I think about beyond my family members? What if they are not available? What if they don't have the knowledge and experience? And of course, we are relying on their ability and their willingness to serve. And I know there's nothing wrong with that. But as long as we build in flexibility, which we're going to talk about a little bit more, everything will end up being okay. We just have to have the time to think through these issues and make sure that the flexibility is there for the long term. Speaking of flexibility, one of the things that we would discuss with you in special needs planning, or basically say to you that these things are important, is having a trust advisory committee inside of the trust. This is part of the flexibility that you can give the trustee so that they have a group, they have the ability to talk to professionals or other people that are involved in the loved one's life and the person with disabilities life to make decisions, to advise the trustee about what is the best decision or to troubleshoot problems. Hopefully there won't be any major problems, but I certainly have seen in my practice and in my serving as trustee of certain trusts, I have certainly seen times when I needed a trust advisory committee. A trust protector is something I strongly encourage you to start learning about. Maryland authorizes the use of a trust protector. Actually, Maryland calls it a trust advisor. And these are independent persons, whether it's your attorney or whether it's your CPA or another independent person who can modify the trust, who can amend the trust. One of the biggest things the trust protector is given the power to do is to remove and replace trustees, to review accountings, and to be able to amend the trust. Now, this may seem like a very earth-shattering concept to you, and if it does, you're perfectly normal. This takes a little while to get your mind around that. This third person that you would appoint has limited powers. They're very strong powers, but they have limited powers to do certain things. These are very important flexibility measures. I've only had a few parents over the years that have said, Steve, I don't want a trust protector. We think that a trust protector is practically as a necessity because so many modern trusts today are drafted with trust protectors. If we don't have a trust protector, then we don't have the flexibility for changes in the future that could arise, changes in the laws, changes in circumstances, and so forth. This is what a contemporary trust looks like in special needs. It's not a one-size-fits-all, but it's a general idea of the things we recommend you should be thinking about. Of course, careful selection of trustees, trust protectors, as I just mentioned, having a provision in the trust for Maryland Able. My trustee may fund a Maryland Able account that I've established. The trustee may hire advocates to make their lives easier, but also to have efficiency in the trust, to make sure that my loved one is being cared for, and to do assessments of my loved one, and also to make sure that they're not being abused. The eyes and ears on the ground, so to speak, including a memorandum of intent that would be attached to the back of the trust. And to keep that memorandum of intent updated every 5 years or so. Save it in a Word document format or something along those lines so that it can be updated. The Trust Advisory Committee, we just talked about that, and optimizing the trust for retirement plans. If you're not familiar with this, people with disabilities, chronically ill people as well, are exempt from the Secure Act, SECURE, all caps Secure Act, that was signed by President Trump in January of 2020. The Secure Act does not treat most people favorably, but it does treat disabled people and chronically ill people and their special needs or supplemental needs trusts. It gives them an exemption. And what that means is that your retirement plan assets, your IRAs or your 401k assets that go to a special needs trust, those assets are exempt from the Secure Act, and that means that your loved one has favorable tax treatment to not have to pay the income tax on that IRA asset unless the trustee uses that money. And I shouldn't say there's no income tax due. Your loved one is exempt, and that means they can use their life expectancy to stretch out the taxation of that IRA asset the way that most people used to be able to do it before the Secure Act. Your disabled or chronically ill loved one can still do that. All right, Jeff, I'm moving slide here a little slowly because my cursor froze on me, but I'm good now. These are perfect trustees. Jeff found these people. I'm just teasing. These individuals are perfect. They know how to keep accountability and to keep accurate records. They keep the beneficiary informed. They comply with their statutory duties. So first of all, these individuals don't have to do all this themselves, although you would want most of them to do this because it would keep costs down. They can keep at least accurate records, but they understand accountability. Now, they have a basic understanding of financial affairs. They don't have to be experts in investing, but what should they do? They should hire professionals. They should hire a financial advisor. They should hire a tax preparer, preferably a CPA, and they should take professional advice. And when they do so, they are fulfilling the highest and best practices of their trustee duties. So the trustee needs to be accountable and responsible. And they also need to understand that their fiduciary duty is, if they are not a professional themselves, if they are not a tax professional, they are not an investment professional, they are to hire professional advisors. And one of the most important things, they are great advocates. They keep the best interest of the beneficiary in mind. They understand public benefits. They're promoting independence and quality of life. So these concentric circles that, and I'm teasing by saying these people are perfect because there is no such thing as a perfect person, but we want to use this standard as our benchmark. Now, what can a supplemental needs trust pay for? Well, the third-party supplemental needs trust is a bit more liberal. The first-party special needs trust must be used for the sole benefit of the beneficiary. The best way that I can describe this is, I would just look at this as anything that is for the benefit of the beneficiary, generally speaking, is fine, except for the fact that the first-party trust is more regulated by the state, and it has to have an accounting, and the expenditures from a first-party trust are more stringently monitored than the third-party trust. But Jeff will be glad to provide a list of things that a special needs trust can pay for as a general guideline. So we are happy to provide that because I know many of you are concerned about that. As we start to work toward the end of the presentation here, in the last 15 minutes or so, the question now becomes, well, how much should I fund into the trust? Do I treat all my children equally? How do I think in terms of how much money? Well, most of us, and if you're in this category, don't be feeling any bad about this or think that you're in a minority of people. Most people are thinking in terms of, when I pass away, I'm going to leave a certain amount to my child and to their special needs trust. And that's perfectly natural. The problem with that is that we really don't know how much we're going to have when we pass away. None of us do. So we don't know what the future holds. So ideally, all parents, all grandparents who would create a trust would fund that trust now. Now, most people don't do that. Most people do not fund the special needs trust during life, or if they do, they don't fund it substantially. So I want you to think in terms of, yes, my estate plan will fund that trust. But the question is, when I work with the financial advisor, when I work with the life insurance specialist, should we be funding this trust now to make sure that we know now how much money is going to be in here? So this is the highest and best thing. This is why I'm encouraging you to have a planning team and to also use your financial advisor as part of that team to run projections and to give you advice. First party trust, as I mentioned, these are the trusts and the tools for people who come into the ownership of assets they're not supposed to have, like that young person who received that large IRA, or like the disabled person, many of them that I've seen that were living in group housing and they were receiving benefits for medication monitoring and transportation and all kinds of other benefits and housing. And then they received an inheritance from someone out of the blue that they were not supposed to receive. These kinds of cases, in those cases, the first party trust can be established and get the money out of the name of that person and get them back on benefits. Personal injury awards from a birth injury or other injury, a surgery injury, from inheritance or a gift, these are the types of things that the first party trust is used for. And just one quick note here at the bottom of this slide, even if you don't anticipate this will ever be the situation that your disabled loved one would receive an inheritance unexpectedly from someone, or they don't have an accident settlement or some other kind of settlement from an injury, it is a best practice to establish a first party trust, and that doesn't take a whole lot to do. We simply draft the trust, send it to the Attorney General for review and approval. They almost always approve the trust, and the trust can be sitting there during lifetime, just sitting there and waiting just in case your child or your loved one ever receives money in their name inadvertently that they're not supposed to have. This would be an easy tool to be able to get the money out of their name and into the trust without a lot of delay. So in a best of all worlds scenario, you would use a third party trust as part of your basic estate planning. And that third party trust can live right inside of your will, or it can live right inside of your revocable trust, or that third party trust can stand on its own. And in many cases, that is the best approach. And in addition, have the first party trust already drafted and approved by the Attorney General. That is a highest and best approach. So as I mentioned earlier, Elville and Associates has a process, and we are a process-driven firm no matter what kind of planning we're doing. And I do apologize for this rather odd circular illustration here, but what we're trying to illustrate is that we have a process, and that process is very important. We educate clients and we take them through a series of meetings, and special needs parents have certain very special considerations, and they need to be thinking about things in a different way. So we facilitate this process in a partnership relationship with our special needs parents and grandparents and others, in really educating through the process, but also making sure that the process eventually ends and that everything is funded properly into the trust. And in the middle of this process here, you see that we believe in a collaborative approach with the advisors, and that you should have an advisory team. This is a narrative form of our process, and you don't have to go through every single meeting here, although we do recommend that, because we feel that we are the only law firm out there that actually educates clients and actually has that as our mission. But what we want to impart here is it's not the number of meetings, it is the substance here of these various topics that we want to make sure you're educated about. As we get towards the end of the presentation, I'm going to revisit now this issue of guardianship or conservatorship. This is a process. I've had parents that come in, and it's very clear over the years, thousands of clients over the years. Parents come in, they know their child needs a guardianship, and we proceed along those lines. But many times guardianship or conservatorship is not so clear. And if you are on this webinar this morning and your loved one is under guardianship, then you've already gone through this process. If you are sitting on the fence about this, this is a counseling issue that we want to take time to think about. Think about your loved one's vulnerabilities, or no, they're higher functioning, they're not suitable for guardianship. And again, hopefully in the near future, we're going to have this tool, this supported decision making, as a not only just whether we should have advanced medical directives and powers of attorney or guardianship, but have something here in the middle that a person could have powers of attorney and advanced directives and a supported decision maker, a supported decision making agreement, or a person that's under guardianship can still have a supported decision maker and not lose all their legal rights in guardianship. So this is a very, very emotional, very sensitive issue with parents and grandparents, and we want to talk about this and talk about the guardianship of the person, which is generally what the court will allow, because most people with disabilities don't have funds in their own name. They don't have money in their own name unless it is Social Security money. And the court will generally say there is no need for a guardianship of the property, a guardianship of the estate, because you as the parent or grandparent or other person is the representative payee. So we don't need a guardianship of the property. However, recent experience is that you will need to be the the guardian of the property of your loved one if you intend to open an ABLE account for the benefit of your loved one. So that is a little nuance that we are recently incorporating. So how do you get started? And I mentioned that we want to facilitate information and education, and we want to be a resource to you. We always will be, but we also want to facilitate a path forward for you. I want you to be encouraged to create a memorandum of intent. Jeff will send that to you if you don't have one, or to create one of your own or use our template. We want you to establish or revisit your old estate plan. Establish a new estate plan, will, trust, powers of attorney, advance directive for yourself. We want to establish a special needs trust as part of your planning. And that special needs trust can be a part of your will or trust itself, or it can stand on its own. And there are pros and cons about this, various counseling issues, and we go through all of those things. We want to work with your advisory team, your financial advisors and insurance professionals to calculate the future needs of your loved one. We also want to address the issues regarding retirement accounts and make sure that a special needs trust is optimized for the Secure Act so that your child or loved one can have the maximum benefit of the maximum stretch out of the growth of the IRA without having to pay tax within 10 years, which is what most other people are having to deal with now because they are not exempt from the Secure Act. We want your loved ones and your trustees to understand public benefits. We want to basically make plans for the future in a very general way. We want to look at advocates and start interviewing advocates and think about that. And generally speaking, we want to make special needs a part of your estate plan that everyone understands. So we want you to consider an appointment with us. We want to provide that path forward for you. Jeff is on the line here to, after this webinar is over, to facilitate an appointment for you for a review or just a general consultation. We also have my personal assistant, Mary Gay Kramer, that Jeff is going to provide the information for. You can also just send an email to me, Steve at Elville Associates. But again, we want to give you multiple paths to be able to have your plan reviewed or to have a consultation. We want you to complete an estate planning questionnaire. This is a little bit of work, just like a memorandum is a lot of work. We want you to participate in the process and give us the information we need. We need all of your information in that kind of relationship so that we can cover all the bases, and that's what an estate planning questionnaire does. It's a very important part, if not the most important part, of beginning the process. We want you to relax. We want you to understand there is nothing to fear. We are here confidentially to discuss things with you. If you've never done this before, I know it's a strange thing to consider. There's nothing to fear. We are here to educate. We want you to bring your current documents with you. So please do. We have clients come in every week with new documents. They come in with their estate planning binders or their old wills or trusts. We are here to review those. We want you to consider your current financial advisory team or your tax team. If you have those and you're happy with those individuals, that is wonderful. And we want to collaborate with them. And if you don't have an advisory team, we want to help you form one, and we can give you our input and our advice about that. I want you and we want you to come in with your questions. Please type them up. Please write them down. It helps our meetings go well. It is very educational in the sense that we are able to respond to your questions. So don't be shy to come in with a list of questions along with your current documents if you have any. And as Jeff and I mentioned, our attorneys here at Elville and Associates, we want to give you the time to think, and we want to help you develop your goals. And if you don't have your goals fully developed through the education process, we're confident that you'll know what your goals are because of your education and participating in the process. So Jeff, I'm going to turn it back to you, and I'm just going to thank everyone for your time and attention. It looks like it's around 11, almost 11:15, so we're ending on time, giving time for more questions. I can't thank you enough for allowing me to spend time with you on this Friday morning. Please know we're here to assist, and we're very blessed to be on this webinar with you this morning and part of the special needs community.
Well, thank you very much, Steve. Really nice job in going through that presentation, and one of our most important presentations that we try to offer every month or two at least. So wanted to mention that after this slide, there are several slides about the Maryland ABLE accounts, and we are fortunate to have a really strong relationship with Maryland ABLE and Miss Kelly Nelson, specifically, who is the outreach coordinator for Maryland ABLE. She's presented with us several times over the years, probably 10 to 12 times, and she is just a wonderful resource. Can't say enough about her. I know Steve would say the same thing. So this is good information about Maryland ABLE and the features and how to get started. So what I'll do in the follow-up email that I send out typically after these webinars is I'll provide her contact information for you. If you have questions about Maryland ABLE, I'll give you her contact information. She can answer any questions and help you set up a Maryland ABLE account, answer questions if you have a current Maryland ABLE account. I'll also send out a recent Maryland ABLE webinar that we offered back in January. That was terrific, that she offers about once every 6 months as part of our webinar series as well. But these slides are used with Kelly's approval. So we thank Kelly for letting us incorporate those in our presentation today. So we do have a couple questions, Steve, that I want to go ahead and run through, and now would be your time to get those final questions in to Steve before we finish up here for the morning. So let me get to the first one here. So the first question is, Steve, is there a minimum amount to establish a third-party trust?
Thank you for that. If I understand your question correctly, I would say no, because the purpose of the trust, remember, is to serve as a bucket. You're creating a world. You're creating a world of support for your loved one that is not going to necessarily be provided by the means tested public benefit system. So I would say any amount that you are going to provide, it would, within reason, any amount is going to need to go into that third party trust. So I would say there's not a minimum, and it just depends on where you're going to, when you're going to fund it and how, but I would not say there's a minimum amount. Now, if there is a very, what we might call in law, a de minimis amount, if there's a very small amount of 10 or 15,000 or 20,000, then it may not be wise to create a third-party special needs trust, and may not be necessary, is what I'm trying to say. But I think generally speaking, depending on where you're coming from and the context you're coming from on that, generally speaking, you're still going to want to provide a third-party trust.
Okay. Next question is, can a trustee get paid in a third-party special needs trust?
And thank you for that wonderful question. And that's a very important question. The answer is yes. So a trustee can be paid and should be paid. And there are two or three ways of thinking about that. So reasonable compensation, these two words, reasonable compensation, that is the general compensation standard in most modern trusts, where the trustee is entitled to, quote, reasonable compensation. Now, the question is, what is reasonable? For a non-professional trustee, reasonable might be $50 an hour. Now, along those lines, there is a statutory provision in the law that says compensation will be statutory according to the Maryland statutes. Now, that's very minimal compensation. And at first, that might seem really desirable because the trustee won't be paid very much. It's limited by Maryland law. But the problem possibly is going to be that the compensation is so little under Maryland law that it's going to discourage someone from serving. So we just want to make sure that we're addressing the compensation issue probably with the standard of reasonable compensation. Corporate fiduciaries, such as banks or other trust companies, they have to file a fee schedule with the Secretary of State. So if we're considering using a bank or a trust company, we can actually see their fees and their fee schedule.
Okay, thank you. Next question, is there a cost range for a third-party special needs trust in setting it up?
That's a great question. All law firms that do these types of things, they are going to have their own fee schedules and their own prices. At Elville & Associates, we are committed to the special needs community and feel privileged to have been a part of it all these years. So we do have standard fees, flat fees, we might call it, for special needs trusts of all kinds. But we also do things on a case-by-case basis. We have all kinds of clients. As you may imagine, we have young parents with young, very, very young disabled children. We have parents with teenage disabled children. We have grandparents coming in to do special needs planning for their grandchildren. We have all kinds of situations, and we try to meet the client's situation where they are and make sure that we're doing everything on our part to make sure they have planning no matter what their financial situation may be.
Next question is advocates. How do I find them?
Wonderful question. So there are a lot of choices here. I would recommend that if you want us to give you some information about advocates or make some recommendations, if you could send an email or we could have a meeting about what your situation is. There are national organizations like National Caregivers, national organizations like that. I apologize. Jeff, I need to get back to the audience about the name of the organization. I'm trying to remember the name of. I apologize. There's a national organization. There are other local organizations. There are what we call aging life care managers, that many of them are good advocates for persons with disabilities. And of course, there are local social workers and so forth. So with an advocate, what I'm really getting at is someone who is probably a medical person like an RN, someone who can be the eyes and ears of the trustee on the ground. So if we could just find out a little bit more about your situation, then we could make a few recommendations to you and you could interview these individuals.
Okay. Next question is, does the disabled adult, try to read this again, must the disabled adult be under 22 years old? He or she could be transferred from SSI to SSDI.
Can you read that again, Jeff? You cut out just a
Yeah.
little bit.
Try to phrase it properly here. Does the disabled adult, must he be under 22 years old? He or she could be transferred from SSI to SSDI.
That's if I understand your question, I think it's a great question. They do not have to be under 22 years old. They just have to be disabled prior to 22. So this might happen when the disabled person is 35 years old and now their parent retires, but they've been on SSI for all of those years, but they were disabled prior to 22. Now they make the transition to a disabled adult child status and are receiving Social Security disability on their parents' work record.
Okay. Question, do you have a CPA in your practice?
Thank you. We do have a CPA in our practice. Our special counsel attorney, Charles Borick, is a CPA, but we also use many outside CPAs to prepare tax returns and also do analysis. So many times we refer clients to an outside CPA for certain types of work. Professor Charles Borick is here, and he is a well-known attorney and CPA as well, and he can perform certain of those analyses.
I think those are all the questions for now. So with that being said, if you have any final questions, now would be that time to get those questions in, please. I'll go ahead and close as I normally do. There are several things I like to send out in a substantive follow-up message to everybody to try to provide some additional value to you. I'll send out the video from today's presentation, the Memorandum of Intent template, also the sheet that reflects the information on uses of special needs trusts, other videos that could be helpful to you, including the ABLE accounts presentation that Kelly Nelson did for us back in January. We did a video presentation on supported decision-making a little while ago that I'll send out. Also, we have a presentation coming up in early April about guardianship and the alternatives that you might want to sign up for. And I'll go ahead and send out that video that we did, presentation that we did a few months ago as well. Also, we just did a presentation on what Steve did yesterday for a financial services organization, trustee selection, how to choose the right one for you. Those are all relevant to this presentation that we just offered. So I'll send those out to you. We will find out that advocates organization that Steve was alluding to as well. I'll send that out. And also check out our events page, elvilleassociates.com/events. We have a packed end of March and a very busy April with some really great new events and webinars, including the second in our mini series with Mr. Andre Lingham, who is the founder of the Center for Elder Justice and Education. He's going to be doing a great presentation on identity theft, the illusion of privacy. We also have a presentation on the basics of Medicare, which is going to be offered by Mr. Mark Trent, who is our featured presenter at our 2017 and 2018 annual client event. And he's going to be coming back to offer that presentation. Really smart and a great, funny guy. You'll walk away with a lot of information and probably get some laughs along the way as well. So we have those presentations as well as many others. I think we probably have 8 presentations in April. So we'll be busy, and I hope you tune in to join us.
Yep, I have now had an epiphany. It's National Care Advisors.
Okay, great. So National Care Advisors. I'll go ahead and make sure I include that in my email. Thank you, Steve.
You're welcome.
National, jot that down real quick. Okay. And if you need, again, last thing I'll say, a referral for a financial advisor, a CPA, we know the very best in the business around here. If you're looking to start your planning, no better time than now. Like Steve said, we are here to create solutions for your needs, offer some peace of mind, give you the time to think, help you determine what your goals are, create a path forward for you. We offer a very unique area here for you to help achieve your goals, and that's what we're here to do. Offer a lot of education along the way. So it'd be our privilege to be a resource to you. So email me, fill out the survey afterwards. It gives you an option to say I'd like to come in for a consultation, and it'd be our pleasure to work with you. So with that said, thank you for being here today. Been a great audience, lots of great questions, and we always appreciate those. And Steve, thanks again for your time as well.
Thank you, Jeff, and thank you, everyone.
Okay, we'll see you all again soon, and thanks for being part of the Elville webinar series. Have a nice weekend.